My name is Tim Sandefur. I'm the Vice President for Legal Affairs here at the Goldwater Institute. And with me is Jon Riches, our Vice President for Litigation. How you doing, John?
Doing great. How about yourself?
All right. Well, we have a whole bunch of Supreme Court decisions, but we've narrowed it down into the five most interesting, and then maybe we can talk a little bit about some of the others as our conversation proceeds. But before I begin, just a brief introduction. The Goldwater Institute, of course, is a nonprofit organization devoted to advancing private property, economic liberty, and other constitutional rights in the courts, legislatures, and in the court of public opinion across the country, as well as here at home in Phoenix, Arizona. And part of our work is the Scharf Norton Center for Constitutional Litigation, where we litigate cases and study and perform legal scholarship on important constitutional questions facing the country. And once again, in case you didn't hear our announcement, you can ask questions as we proceed in the Q&A box that's located at the bottom of your screen. John, why don't you kick it off with our first case, the EPA case that the Supreme Court decided this past term.
Sure. Thanks, Tim. And this is an interesting one and a crucially important one in this area of administrative law in the administrative state. So the question that the court was confronted with is whether the Environmental Protection Agency, the Federal Environmental Protection Agency, had congressional authority to impose an emissions reduction scheme that would essentially require the fossil fuel industry to shift to so-called renewable sources of energy. So whether the agency had statutory authorization to impose a rule across a broad industry. So the facts briefly, in 2016, Congress considered but failed to adopt a very similar sort of cap and trade scheme that was intended to reduce greenhouse gases. Following that failure in Congress, the EPA claimed that it had independent authority to issue a rule that essentially adopted that policy under a somewhat obscure provision of the Federal Clean Air Act. So West Virginia challenged the rule, and the state claimed that the EPA lacked delegated authority from Congress. Now, of course, remember that under the Constitution, all legislative power is vested in Congress, and we'll have a chance to talk a little bit more about that, but all legislative power, not some, all legislative power is vested in the Congress. Here, though, the Obama administration, and there's somewhat of a complicated procedural fact pattern, which maybe we'll have a chance to chat a little bit more about, but on the merits, here, the Obama administration argued that the Clean Air Act's phrase, quote, best system for emission reduction, that was the phrase in the Clean Air Act, authorized the EPA to regulate not just individual factories or businesses, but to impose a sector-wide regulation. And writing for the court, Justice Roberts found that the Clean Air Act did not go that far. Instead, the EPA's rule was an effort to regulate carbon emissions for an entire industry. And that was impermissible under what's called the major questions doctrine. What that says is that if Congress is really going to delegate something to an administrative agency, an unelected administrative agency, and if the decision involves vast economic and political consequences, then Congress has to delegate that authority clearly. And the section of the Clean Air Act on which the EPA relied in this case was really just a gap filler. It wasn't a clear delegation of congressional authority to what the court said would allow the agency to exercise, quote, unprecedented power over an American industry. So why is that important? Why is it important that if an administrative agency is going to act particularly on major issues, it has to have clear and express delegation from Congress. Well, because as Justice Gorsuch observed in his dissent, if this were allowed to happen, if this were to be the scheme in our system of government, it would, quote, dash our entire constitutional separation of powers. It would transform the lawmaking process, which of course is intended to be difficult, intended to be built on consensus, intended to protect the views of minority, and transform our carefully wrought constitutional system into one in which any administrator, in which any one administration can essentially impose its view of the law at will. And that is not our system. So that was the decision of the court.
But John, it's so hard to get laws passed by Congress. If this is the right answer, shouldn't we just impose the right answer? I mean, why should we have necessarily spend all this time with all this democratic lawmaking procedure?
Right. I mean, so this is what the other side argued. Like they said, look, it's really, really hard on complicated questions, that it's hard to get laws enacted, specifically when you're dealing with complicated questions. Well, and look, I mean, that's the whole point, right? That's the reason we have two chambers in the Congress and not just one. That's the reason why you have an executive that can check, that can veto legislation. That's the reason why all interests come to the table when they're developing legislation. And certain special interests can't just capture one regulator and then have their will. So that's essentially what the court said. And the decision really breathed life into the major questions doctrine, which up until this decision had been relatively dormant. So question for you, Tim. I think this is a great decision. It's limiting the authority of the administrative state, an issue, of course, we've worked on a great deal here at Goldwater. But how far does it go? I think the court sort of went out of its way to say, look, this was a rule that would have cost billions of dollars in compliance. It would have raised utility rates. It would have impacted employment for tens of thousands of people. That's a really major question. And I think very few people would argue that that's a major question. So what do you think? I mean, does this have broader applicability?
Oh, it certainly does. And I think, of course, what you and I have published on the subject of the administrative state and the danger that it poses to democracy, because it seems to be to offer an end run around the lawmaking process, to just say, well, if I can't get my law passed, then I'll just instruct the bureaucrats to find some way to interpret existing law to give them the authority they want. And, that can be really broad. My favorite recent example of this actually is a decision from the California state courts, which recently decided that insects are fish under state law, because state law gives the regulatory agency authority over fish, and then defines that term so broadly that you can actually say that an insect is a fish, and therefore the agency has authority. I mean, that kind of argument would take away our ability to really control the laws under which we live our lives. So this is reining in the administrative bureaucratic state is very important. And it's not something that should be a Republican Democrat thing, because you're talking about whether the voters have any real control over the laws that they are forced to obey. That's something that I would hope all Americans can agree that those kinds of questions should at least be decided by our elected representatives within constitutional boundaries. Unfortunately, the courts, over the past century, the courts invented various mechanisms for giving these bureaucracies more power, these deference doctrines. And I think, of course, the most infamous of these is Chevron deference doctrine. I think the major questions doctrine is a way of trying to avoid confronting that legacy and to find a way of restricting administrative agency power within constitutional boundaries without really resolving those deference doctrines that are left over from a century ago. But I mean, obviously, only time will tell about that.
Yeah, and you raise an interesting point, which the facts of this case, I think, made it clear. So the way this came up is the Obama administration was the one to put in place the rule that was challenged. When President Trump was elected, his administration engaged in its own rulemaking that repealed the Obama era rule. And so there was a question before the court. Well, now the Biden administration is in power, and is there really even standing here to take this up, considering that the Biden administration has said, well, we're not going to do exactly what the Obama administration does, but in substance, we basically agree with it. That raises some interesting standing questions, but I think it gets to your deeper point, Tim, that, look, if this is the rule, if administrative agencies can just do what they want on major issues like this willy-nilly, well, then every change in administration is going to have a major change in policy. And that's not the way.
Yes. And one of the crucial aspects of our Constitution is that it's not that way in America. In a lot of other countries, in banana republics, every time somebody new gets elected, all of the laws change and the whole system gets thrown out, and you can't really predict what's going to happen, at the end of the existing dictator's term in office or whatever. And our system is supposed to emphasize continuity. That's why we have a staggered system where the president and the Congress aren't elected all at the same time and that sort of thing. If it gets handed over to the administrative agencies, and the administrative agencies are ruled over by the president, then you will move in the direction of having a society where everything just radically is different every 4 years. Every one of the laws under which we live our lives is subject to transformation overnight. That's really not a good idea.
Totally. And what does that say of the rule of law, people's respect for the law, et cetera, the consequences go on. We got a question from Gary here. He asked, each state has its own, essentially EPA version, Department of Environmental Quality, or whatever they might be at the state level. Should they be included in any so-called nationwide rules? I think that's kind of an interesting point. Oftentimes, these state administrative agencies that have a federal analog will adopt similar rules that the federal government does. So, to the extent that the Supreme Court said, this one's out, maybe individual states could try to impose something, at their own level, but I think it makes it less likely. And I think it also raises potential dormant commerce clause issues if they try to regulate an area that affects commerce among the other states. Don't know if you have anything to add to that, Tim.
No, let's proceed on to the next case, because we got 5 cases we got to get over in an hour. So I want to talk a little bit about guns. And actually, the guns case actually does connect to what we were just talking about, because it does affect these administrative agencies and the rules that they operate under. The gun case from New York State, the state law said that were required to show a special need of some sort before you were allowed to possess a firearm. And this was a relatively unusual law. Although there are laws of that sort on the books in some states, most states don't require you to show some unspecified, unique need for a firearm before you can possess one. And the Supreme Court was asked to decide whether that was constitutional or not, and said no. And in the broader sense, putting aside the question of guns, what's interesting about that is this broader question about special need requirements for permits of all sorts. Like, for instance, when you need a building permit, or if you need a permit to have a parade or a protest march, or a permit to exercise any one of our constitutional rights. These are pervasive throughout our society. Licensing laws, for instance, to run a business or to practice a certain profession. Those are really permit requirements. The question is, can you be required to show a special need, whatever that might be, before you're allowed to exercise those rights? That has been a particular interest of ours. We've advocated, for instance, we've proposed a law we call permit freedom, which would require the government to have objective standards whenever it imposes any kind of permit requirement of any sort, not subjective, touchy-feely, vague standards like special need. Now, unfortunately, although the Supreme Court struck down the New York law, it really didn't talk a lot about this special need requirement. Most of the decision is emphasizing the history of firearm possession, your right to possess firearms or other kinds of weapons, and the history of government's power to regulate it. But there was a paragraph at the very end of the decision where Justice Thomas made what I thought was a very important and valid point. He says that this idea of being required to show a special need is very unusual. He says, this is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. Our constitutional rights aren't supposed to be subject to this requirement to show a special need before you're allowed to exercise that right. And I very much hope that the court in future cases will emphasize this point more, particularly in cases involving private property rights and economic liberty, where the standards for getting a permit can be incredibly vague. And what do vague standards do? They give power to bureaucrats. If the bureaucrat gets to decide what is a special need, then the bureaucrat is in the position of saying who gets a firearm and who doesn't. Getting to define the term special need also gives the bureaucracy power to demand something from you in exchange for that permit, which you often see in the building industry, for example. The government says, well, you can have your building permit, but you have to give us land or even cash outright in exchange for a building permit and that sort of thing. That's an improper restriction on our constitutional rights that empowers government at our expense.
It's such a fundamental question. I mean, do we have the ability to exercise our rights free of government restraint, or must we first go to government and ask Mother May I before we can do that? And I know that's a cause that you've written an awful lot about in your Permission Society, among others. And, you know, in so much of our work, we try to get back to the presumption of liberty rather than the presumption that we must seek permission. I want to ask you something, a couple questions. The first, as you mentioned, Justice Thomas observed that, hey, look, I mean, other rights don't work this way. We got to go to the government and say, hey, can I do this thing? But as you pointed out, some rights, they do work that way, right? I mean, when we want to exercise our right to own private property, as you say, you know, maybe I want to do a home addition. Well, then I got to go to the government and ask for permission to do that. Or the right to earn a living. We've got to go to the government and ask for an occupational license before I can practice my trade. So interesting that he made that observation, obviously crucially important, but I don't think it's the case that other constitutional rights don't have this requirement, because some plainly do.
In practice, they do. And the Supreme Court's been kind of vague in answering these kinds of questions, and largely because it just hasn't been raised in previous cases. But there's a very interesting footnote in a Supreme Court case called Nolan versus California Coastal Commission from the 1980s, where the dissenting judges are saying, well, building permits are different because, you know, they're a special privilege that the government gives you. And Justice Scalia, who wrote the majority opinion in that case, put in a footnote where he said that there are under no circumstances can the right to use your private property be regarded as simply a government privilege that you have to ask the government for. I think the Supreme Court really needs to emphasize that point in a future case. And as far as licensing laws for businesses, it's true there are some professions that require a license. And the Supreme Court first addressed this question in a 19th century case called Dent versus West Virginia. And there the Supreme Court said doctors can be required to get a medical license before they can practice. But the court also went on to say, but the requirements for getting a license have to be clear, and they have to be the kind of thing that a person can acquire through a medical education. If they're too vague or too demanding, then they violate the Constitution because they take away your right to earn a living. And unfortunately, since then, the Supreme Court's never really enforced that rule. It's basically looked the other way and allowed states to impose licensing requirements or permit requirements on private property, economic liberty, and a host of other things without really enforcing constitutional safeguards. Before we leave this, one other point. In the 1950s, the Supreme Court did adopt a rule, again, which has been ignored, that says that anytime the government imposes a permit requirement on any exercise of constitutional rights, there are three what they call procedural safeguards that the government has to follow. The criteria for getting the permit have to be clear and unambiguous. There has to be a deadline within which you will get an answer as to whether you'll get your permit or not. They can't just string you along once you apply. And there has to be an opportunity for judicial review before a neutral judge about whether or not you were wrongly denied a permit, if you think that's the case. And the Supreme Court said that applies for all permit requirements, and then has ignored the subject since then. That was the 1950s, and state and local governments have disregarded those constitutionally mandated procedural safeguards and permit requirements ever since, and it's a real shame. Let's move on as soon as we can to your next administrative law case, which kind of builds on some of these things we've been talking about. And I saw there was at least one question about this case already. So let's talk about the mask mandate case, the vaccine mandate case is what I meant to say, the OSHA case.
Yep. And another administrative law case. I think we're going to see an awful lot of major administrative law cases come down from this court. There's members, particularly Justice Gorsuch and Justice Kavanaugh, that have particular expertise and interest in this area of admin law. And, while obviously we deal with this sort of stuff as public interest litigators that care about separation of powers and limited government, for the broader public, I think there's not a lot of thought that's given to how dangerous our administrative state can be. So it's really nice to see so many marquee decisions in this area. So the next one involved the Occupational Safety and Health Administration, OSHA's rule that attempted to impose a nationwide vaccine or test and wear a mask mandate on all private employers that had 100 or more employees by rulemaking. So in November 2021, OSHA issued this rule saying, look, if you're a large employer, I guess maybe that's not even accurate. If you're an employer with over 100 employees, which, by the way, is 2/3 of every single business in the United States, then you must require your employees to receive a vaccine or to be tested for COVID-19, or to be tested weekly and to wear masks at work. And the mandate would have affected about 85 million American workers. If a business did not comply with the rule and they didn't, quote, remove from the workplace an employee that hadn't complied with this regulatory requirement, the business could be fined $13,653 for what the agency characterized as a standard violation, or $136,000 for what the agency characterized as a willful violation. Again, this goes to the breadth of power of these administrative agencies. I mean, imposing these crippling fines when no elected lawmaker has ever decided to do anything like this. Interestingly, the court observed that OSHA, which of course is an agency that's dedicated to workplace safety, right? If it's a mine, then OSHA, will determine whether there's specific occupational hazards that might exist, or a doctor's office specific to that occupation. OSHA had never attempted to adopt a regulation of this broad, sweeping magnitude that affected 85 million employees in one broad stroke. So a number of entities challenged this rule. They argued that it exceeded OSHA's statutory authorization. The court issued a per curiam decision that found that Congress had given OSHA the power to establish safety standards in the workplace, but not these broad public health measures that affect so many workers. And the court observed that, look, COVID might be a risk in the workplace, but it's not a unique risk to workplaces generally. It can spread anywhere. So it's no different than any other type of risk or danger, like crime or anything else that somebody might encounter as they go about their daily lives. So the court sort of drew this distinction between occupational risks, which maybe OSHA would have some authority over, and risks generally like this one, which they plainly did not. The court found that permitting OSHA to regulate the hazards of daily life simply because most Americans have jobs and face those risks while on the clock would significantly expand OSHA's regulatory authority without clear congressional authorization. So again, the decision comes down to, or the question comes down to, who's better at making these decisions?
John, this one particularly, even more than the EPA case, I think, really emphasize or underscores the importance of making sure the lawmaking power is in the hands of elected representatives instead of these regulatory agencies, for a couple of reasons. The first one is, one reason why the vaccine mandate thing was done through an administrative agency is precisely because it was very politically unpopular. And Congress and the president knew it could not be done through the congressional lawmaking system established by the Constitution, precisely because a large number of Americans oppose such an idea and don't think it ought to be law. And that attitude is then characterized as gridlock and treat it as if it's a bad thing or a breakdown in government because Congress isn't getting anything done. Congress often doesn't get things done because the American people, or at least a very large part of the American people, don't want those things done. And if this government is a government of the people and not of the superiors who tell us how to live our lives, it's all the more important to keep these regulatory entities within their boundaries. And the second reason is because Congress, when it does create these agencies, often gives them a very broadly phrased authority to like regulate in the public interest and terms like that, which if taken literally would be giving away the lawmaking power. And John Locke says in his second treatise of civil government, which was, basically like the Bible of government for the American founding fathers, when we get together to create a legislature, we give them the power to create laws, not to create lawmakers. We don't give Congress the power to create the lawmaker. We give Congress the power to create the laws because ultimately we, the people, are in charge. If Congress can just give away its lawmaking authority, it could just give it away to a single person and then adjourn permanently, right? That's not what our founding fathers envisioned as a constitutionally structured democracy. And those are the principles that I think are really at risk in these kinds of cases.
Totally. So I think this actually raises this distinction between non-delegation and major questions. And not to nerd out too much, but what the court said here is, look, you can't, an administrative agency can't act on a major question without specific authorization from Congress. What the non-delegation doctrine says is Congress can't delegate its lawmaking authority to administrative agency. So I guess the question is, can something pass the major questions doctrine? Can Congress give an agency specific, authorization over a big area, but still fail as an unconstitutional delegation of power?
I would speculate that the right answer to that is that it's one or the other. If the broader the delegation of power to the agency, and therefore the more likely it is to pass the major questions test, the more likely it is to fall over into being an unconstitutional delegation, because the Constitution says all legislative powers herein granted are vested in Congress and not vested in somebody else.
Yep. Yeah, I think that's right. And I think Justice Gorsuch sort of examined these together to kind of get at this point.
Yeah, Gorsuch, of course, was largely nominated to the court because of his attentiveness to these questions about administrative agencies. He had written a kind of a blockbuster decision as a Court of Appeals judge, arguing against the Chevron deference doctrine, which is one of these pro-bureaucracy doctrines that I mentioned earlier. And that was largely responsible for getting him the nomination on the Supreme Court. So it's refreshing to know there are justices who take these questions very seriously.
And just real briefly, since you brought up Chevron, this is this issue where if an administrative agency makes a decision where it interprets a statute, and then that decision ends up going to court, the U.S. Supreme Court has said, well, we're going to put our thumb on the scale for the agency and defer to the agency's interpretation of an arguably ambiguous statute. So that's a pretty remarkable doctrine. That means administrative agencies can, come up with rules, investigate the rules, adjudicate the rules with ALJs. And then when they get to actual court, they get, a thumb on the scale if there's a dispute about some particular area of the law. So of course, we at Goldwater have done a lot of work in this area. And while so much of the focus has been on this deference issue at the federal level, it's equally, perhaps more pernicious at the state level, where state administrative agencies are making decisions about where we can work, when we can work, what types of businesses we can start, et cetera, and they're getting deference. And while so many people have conceived of this as a judicial problem, because of course the courts created it, there is a clear legislative solution to this as well, where you could amend Administrative Procedures Act to say, no, when decisions come out of administrative agencies, both parties are going to get fair review. And the Goldwater Institute did that. We proposed an amendment to Arizona's APA, the first state in the country to pass a statutory amendment like that. Other states are now considering it. But I think it's crucially important to think of this issue both at the state level, not just the federal level, and as a legislative issue and not just a judicial issue.
Definitely. People largely underestimate the influence. Well, they underestimate the influence that their entire state government has on their lives because the news, CNN and Fox News are always covering what goes on in Washington, D.C., and it's easy sometimes to forget that even under today's system, most of the laws that govern your life are decided upon at your state legislature. So it is still, or by state bureaucracies, which should not be the case.
All right. Do we want to move on to the next case?
Actually, speaking of states and the federal government, right? Relationship to the federal government, this one actually does blend into those two. I'm sorry, I didn't mean to cut you off. What we were talking about here is the Maine decision about school choice, which is called Carson. And this is a case where the state of Maine had a school choice program that allowed parents who lived in areas that were not served by a public school to get money that they would normally have gone to a public school and spend that money to send their child to a private school. And then the program did not allow the parents to choose a religious school for their children. And that, the state said, was because the state has a constitutional prohibition on the use of government funding in a way that might subsidize a religious institution, a church or whatever. And the Supreme Court said that that violated the free exercise clause of the First Amendment because it essentially discriminated against religious schools and in favor of non-religious private schools. Now, this, of course, we are longtime advocates of school choice. We believe parents have the right to decide for themselves what schools and what educational options are best for their children, and that the state ought to respect that right instead of taking it away, even if, the parents, heaven forbid, decide to send their kids to a religious institution, right? But there's a broader issue in this case, or a couple broader issues in this case, that I really am curious to see how the court is going to resolve in the coming years. And what I mean by that is there's always been this tension in First Amendment law between equal treatment and non-subsidization. What I mean by non-subsidization is your right not to be forced to subsidize a church with your tax dollars. And non-subsidization is really one of the bedrock principles of American freedom of religion. I mean, that Thomas Jefferson's Statute of Virginia for religious freedom, which was the great path-breaking law to establish religious freedom in the United States, when it was passed in Virginia in the 1780s, that law prohibited the state from subsidizing religious institutions and churches with taxpayer dollars. And Jefferson says in that bill, it's wrong to force people, to compel people to support religious doctrines they don't believe in. So non-subsidization is an important keystone of our constitutional system of protecting individual rights. On the other hand, when you have a system like in today's public education system where the state is monopolizing the entire industry, right, takes over the entire field, basically, for the state then to rule out churches from participating, say, well, they can't receive the taxpayer funding that goes to everybody else in the area, well, then that turns into discrimination, and that kind of discrimination can violate the free exercise clause because you're burdening people based on their religious freedom. And so how to reconcile that tension has long been a problem for the court. Now, this is complicated by the fact that in the 19th century, lots of states adopted constitutional protections called the Blaine Amendments that more explicitly prohibit the government from funding religious institutions than does the federal First Amendment. First Amendment just says government may not establish religion. But a lot of state constitutions say also the government cannot fund, even indirectly, a religious institution. And interpreting those clauses, of course, that's up to the state courts because that's a state constitution. So what the Supreme Court said in this case is they said that for the state to provide funding to parents, and then the parents get to decide for themselves where to send their children. And if they choose to send their children to a religious school, that does not violate the Establishment Clause of the First Amendment to the U.S. Constitution. But of course, they don't say and can't say whether that violates state constitutions. Can state constitutions or state laws separate church and state more than the First Amendment requires? They don't really answer that question. And that's the big question, I think, that we're all going to have to deal with, not just in school choice, but in a wide variety of areas in the coming years. And there's a second tension, by the way. And that second tension is between what I will call the Sherbert and the Smith principles. The Sherbert principle is from a case called Sherbert versus Werner. And the Smith principle is from a case called Employment Division versus Smith. And these cases have been kind of in tension for many years. And the reason why that's a problem is the Smith case says, if you have a law that just applies to everybody across the board and it doesn't have any kind of religious motive to it, then you are not exempt from that law, even if your religion, causes problems with that law. So, for example, if the law says no hats, then what about a Jew who wants to wear a yarmulke or what have you? Does he have to take off his hat? What the Supreme Court said in Smith is you don't have a constitutional right to wear your yarmulke if the law says no head coverings. The government can give you an exemption, but you aren't entitled to one under the Constitution. So that's the no accommodation rule. The Smith rule says the opposite. It says that if your religious ideology or religious beliefs clash with a general statute, then that general statute might be unconstitutional if it imposes a really big burden on you. So the tension between those two principles, how much does the government have to accommodate religious believers under the Constitution? That's something that has judges and lawyers have wrestled with for a long time. And it's notable that in this case, the Supreme Court doesn't cite Smith. It cites that Sherbert case, which is an older case. It's much older than Smith. And a lot of people thought Smith had basically overruled Sherbert. So the fact that Sherbert seems to be on the rebound now, I think indicates that in the coming years, we're going to see the court requiring the government to accommodate religious belief more broadly than it used to. It used to say, as long as the law is non-discriminatory, you don't have any excuse, even if your religion clashes with that law. And I think that principle might start to erode over the coming years. That's nerding out, sorry, but I just think it's a really interesting constitutional issue.
Yeah, it is, and I think interesting they didn't mention Smith at all. What implications do you think this has for the broader school choice movement?
Unfortunately, I think it doesn't have as broad implications as advocates of school choice might hope. I mean, it's obviously a great step forward. It's really a good case for those of us who believe that in expanding the right of parents to decide for themselves and their kids what their educational needs are. But the main program only applied in districts where there was no public school that was conveniently available. And this was kind of designed as an alternative for those parents in those out of the way rural areas. And it's hard to tell how much that fact could be used to limit this decision. The court emphasizes it a couple times in the opinion. And I can see in a future case, if you were to just bring a straightforward case about school choice, I can see some future Supreme Court saying, well, that Maine situation was different because there wasn't a public school alternative available. So it's hard to see whether this Maine case will also apply where there is a public school alternative available, but parents would simply prefer that their tax dollars and their children go to the school of their choice.
Yep. We got a good question from Gary here. So Gary observed that ESA expansion. ESAs, of course, are educational savings accounts. They were originally developed by the Goldwater Institute. They allow the amount of state funding that would otherwise go with a student to a district school to be used by that family for the school of their choice. And Gary asked, does the ESA expansion from last legislative session conflict with our state constitution under the Blaine amendments that you had mentioned, Tim?
No, the easy answer to that is no. There was a Supreme Court case called Cotterman some years ago that said no, the ESA program is constitutional even with the Blaine amendments. And the reason being that the money in that situation does not go from the state to the religious institution. ESAs are not school vouchers. I know the Arizona Republic refuses to acknowledge this fact, which is kind of obnoxious, but ESAs are actually quite different than vouchers. Vouchers are where the state takes out a checkbook, writes a check to this religious institution and sends it there because that's where the parents want it to go. In the ESA program, the funding goes to the parent. And the parent participates in the program, makes purchases, and the state ensures that those purchases are legitimately for educational needs, and then is reimbursed from the ESA account that the parent is assigned. So the money never actually goes from the state to the church, and that was really important in that earlier decision. So no, the expansion does not really threaten that, and the Supreme Court has already decided that. And that's one reason we think ESAs are really a better alternative than the old voucher proposals.
Well, there is one other case we haven't discussed yet of the term. Do you want to discuss the Dobbs decision?
Yeah, so let's talk a little bit about the abortion case. I know it's the hot button issue. Now, what I think is interesting about Dobbs, which overturned Roe versus Wade, of course, what that means is that it's up to states to decide whether or not abortion is legal or not. It does not. The Dobbs decision did not outlaw abortion nationwide. It simply said that the states can decide for themselves. In some states, their constitutions already protect abortion rights. Kansas just recently, this is pretty interesting, the Kansas Supreme Court had issued a decision saying abortion rights are protected under the state constitution. Then there was a ballot initiative to overturn that Supreme Court decision, and that failed at the recent election just a few days ago. So that's the kind of argument we're going to see going forward is on this state-by-state level. But what I think is interesting about Dobbs is a little bit more broad than that. And actually, I see that we have a question in the Q&A here that gets to just the point that I was going to say, is that what I think is interesting about Dobbs is how do you define what a fundamental constitutional right is? So the U.S. Constitution protects liberty against certain kinds of violations. That's the word it uses, liberty. So what liberty is protected by the Constitution? Well, judges have to interpret that, and they have to decide what liberties are or are not protected. And one thing that they've done in resolving that question is to distinguish between fundamental rights and non-fundamental rights. What are fundamental rights? Well, the Supreme Court, you would think, well, that's an important right? A non-fundamental right is not an important right, and a fundamental right is a really important right. It's not quite like that. Instead, what the Supreme Court has done is it's kind of gone on a case-by-case basis, and it's created two different tests for determining what is a fundamental right. And that is the history test and the theory test. The history test, it uses a phrase, a slogan from an old Supreme Court case. They say, deeply rooted in the nation's history and tradition. If you're right, if the right you're talking about is deeply rooted in the nation's history and tradition, then it's a fundamentally protected constitutional right. The theory test is a little different. The theory test says, is this right implicit in the concept of ordered liberty? In other words, putting aside the history question, can there be liberty without the right that you're talking about? So, for example, freedom of speech. Take freedom of speech. If you use the history test, you would say, well, freedom of speech has historically been protected by our constitutional system. And of course, before the Constitution was written, by the English common law. And you can go back to, however far back in the common law you want to. And this is what I mentioned earlier, the guns case. That's what Justice Thomas does in the guns case, right? He goes through a lot of this history. He goes back to the medieval times. And do you have a right to carry a sword at the farmer's market in Newport and all these sorts of things? Well, that's the history test. And those who like the history test, they like it because it seems to be objective to them. They think that it's not subjective. It's not just a judge making stuff up. You look through the history books, and so therefore it's clear cut. On the other hand, there's the theory test, this implicit in the concept of ordered liberty test. And one of the criticisms of that is that it seems like it's vague. It seems like the judges are just imposing their own preferences. That's not really fair, though, because this theory test is a philosophical test that talks about natural rights and natural law that our founding fathers believed very strongly in, as did the authors of the 14th Amendment in the 1860s. If you read their speeches and writings, they don't say, oh, this natural rights thing is too vague to be applied. No, they say, of course, judges, no less than anybody else, can determine what is a natural right. And so the natural rights thing, that natural rights tend to fall more on the theory side than on the history side. And if you think about it, that makes sense because natural rights are different than historical rights. Historical rights are about tradition. Natural rights are about what it means to be human, about what kind of freedoms we have to have in order to be free people. And so that tension between the history test and the theory test has gone back and forth throughout history. What I think is interesting and important about Dobbs in a broader sense, broader than the abortion question, is what direction is the court going to go in this question about what is a fundamental right? And they are definitely going in the history direction. They want it to be rooted in history. They want to be able to look at historical tradition, at legal precedent, at other kinds of cultural traditions and habits that have evolved over time in order to find what rights are fundamental. Justice Thomas, in particular, emphasizes this very strongly in his separate opinion in that case, where he calls for the abolition of a theory called substantive due process. Now, substantive due process is the oldest and most important of all of our constitutional protections. It dates back to the Magna Carta, which included a phrase called law of the land. Law of the land is synonymous with due process of law. So we're talking about a constitutional protection that dates back, practically 1,000 years. Justice Thomas wants to eliminate it and replace it with a history test that says, can we ground this in history? Now, that sounds really dangerous. But he then comes back and says, no, this is not a danger because there's another clause of the Constitution that I want to bring in instead that will protect individual rights. And so it won't be a problem. And that's the privileges or immunities clause of the 14th Amendment. That clause was basically erased from the Constitution in the 1870s in a Supreme Court decision called the Slaughterhouse Cases, and which was clearly wrong. We at the Goldwater Institute have frequently argued that the Slaughterhouse Cases should be reversed and that the privileges or immunities clause of the 14th Amendment ought to be revived, just as Justice Thomas says. Whether that's a good argument for eliminating substantive due process is another question. Personally, I think both are really strong and important protections for individual rights. And my own view is I think that the theory approach is just as good, if not better, than the history approach to determining what rights are protected by the Constitution. Now, that sounds like a whole bunch of philosophy and abstraction and stuff, but remember, we have a constitutional system that entrusts judges and lawyers with deciding enormously complicated questions like what is liberty? I mean, that's about as broad a question as you can get, right? And so using the tools of political philosophy and theory and history is perfectly legitimate for judges and lawyers to do. Okay, that's my big pitch on why Dobbs is important over and above the question of abortion rights.
Yeah, and Tim, I think you really you address this issue of privileges and immunities versus due process, and I think Justice Thomas makes somewhat of a fair point. Like, is due process intended to be a procedural, not a substantive safeguard? And really, are our substantive safeguards more properly rooted in the privileges and immunities clause? Big debate in the conservative libertarian legal community within and among different groups there. But
let me put in a plug here for in my book, the Conscience of the Constitution. I have a couple chapters on substantive due process, and the argument, the reason why I think this is misguided in a lot of these debates, and because I know people listening in are going to hear these debates, on the radio and in television, and if you're lawyers at your CLE meetings and so forth. Remember that the due process clause does not protect any kind of process, right? It doesn't say that a coin toss or consulting the Zodiac would be the kind of process that is protected by the Constitution. Instead, what's protected is a legal process, the process of law. What is a process of law? Well, what it means is the opposite of arbitrariness. It means government can't take your rights away just because it feels like it. It can take your freedom away for good reason. So then the question, and whenever your freedom is taken away, you go to a judge, you say, Your Honor, they're wrongly taking my freedom away. The question is, are they doing it for a good reason, or are they doing it just because they want to? And that necessarily involves the judge in these theory questions about what kinds of rights are protected and against what kind of restrictions and so forth. And those questions cannot be answered just by history. For one reason, because government's always coming up with new ways to violate your rights.
All right. Any other thoughts on federalism, stare decisis, anything like that you want to discuss from Dobbs?
Well, Dobbs definitely, I see there's a question, does Dobbs move the ball measurably back towards federalism? Well, it certainly gives a lot of power back to states to decide independently whether or not to allow or prohibit abortion and on what terms. And of course, many states are already engaged in the process of passing these kinds of laws and deciding those kinds of questions. Now, there is the possibility that Congress could decide to act on top of that. We have a lot of legal precedents on the books for almost a century now that say Congress's power to regulate commerce among the several states is extremely broad, extremely broad. We think that's wrong. We think that it ought to only apply to commercial transactions. But in any event, the existing precedent allows Congress extremely broad authority to regulate things that go on from state to state and even things that go on within a single state. So it is not beyond reason to expect Congress to take federal steps also to restrict abortion if Congress has the votes to do so. Right now, a person might travel from one state to another to obtain an abortion. There's no real reason at present that I can think of that Congress could not prohibit that, could come in and say, no, you aren't allowed to travel from one state to another to obtain an abortion. Under the existing precedent, I think that would be absolutely a possibility for Congress to do. Whether that would be politically palatable, I don't know. What the next steps are in the courts or constitutional reform or whatever, I don't know. But that is, this question about federalism, for now, yes, the states have a lot of authority, but it is possible that Congress could come in and try and act federally also.
I want to make sure we had a couple more Dobbs questions, but I want to make sure we got enough time for predictions about next term and important cases that.
I know them all, John. I know how all the cases are going to come out. And so I'm going to head down to my bookie and lay some money down on some of these decisions.
What do you think? What would you like to see come up in the 2023 term?
Well, the three big cases that we know for sure they're going to talk about there is the Indian Child Welfare Act case, the Sackett case, and the Affirmative Action case. So the Indian Child Welfare Act case, of course, that's a major project for the Goldwater Institute, is this act which restricts the ability to adopt or to foster or to protect Indian children against abuse or mistreatment. An Indian child is defined as not only the child who's a tribal member, but a child who is eligible, biologically eligible for membership in a tribe. And this has been a major focus of our work over the years. The Supreme Court is going to be hearing an argument against the constitutionality of that act in early November. And so we're very eager to see how the court's going to rule on two questions in that case. The first one is whether that's racially discriminatory. And the second one is, like we were just talking about federalism, whether or not that violates the principles of federalism that leaves questions about adoption and foster care and child protection at the state level. The next one is Sackett. Sackett is an environmental law case that is very old now. It is being litigated by our friends at Pacific Legal Foundation, and they went to the Supreme Court with this case, at least 10 years ago already, and now they're back at the Supreme Court. That's a case where the federal government came in and said to this couple they weren't allowed to develop on their land because it was a wetland. It was dry land, but the federal government said it was a wetland because, sometimes it gets wet. Right. And the federal Constitution allows Congress the power to regulate interstate commerce, which allows Congress the power to regulate waterways. So then the question is, are wetlands part of the waters of the United States? We're talking about dry land that you can walk across without getting your feet wet. And this federal government says it's a water of the United States. And this goes back to what we were talking about at the very beginning about these administrative agencies get to define the scope of their own power in some ways. And so the question there is, what is the definition of wetland? And when does dry land qualify as a water of the United States? And then, of course, the affirmative action case, which comes out of higher education, as a lot of these cases do. Now, you'll remember, I think it was, a dozen years ago or so, the Supreme Court decided a case called Gruder versus Bollinger. And in that case, it said that affirmative action in higher education, race preferences are okay because they serve an important educational purpose. But truly bizarre, the court then put a 25-year time limit on that and said in 25 years, it will suddenly become unconstitutional for the government to discriminate against students based on their race. Justice Thomas, in what I thought was an amusing opinion, wrote a concurring opinion where he sort of agreed to that. He said, yes, I agree that will be unconstitutional in 25 years, but it's also unconstitutional now. So the clock's been ticking, and I have a sneaking suspicion that he's going to want to kind of advance the clock and move forward into the future when the government is no longer allowed to discriminate against people on the basis of the color of their skin. What a shocking and extreme proposition that is. How about you, John? Are there any cases you're looking forward to?
Well, I think the area of admin law is going to continue to be a major area. I think Chevron is on life support, and given the right set of facts, I think the currently constituted Supreme Court, would seriously consider eliminating or significantly curtailing the Chevron doctrine, allowing agencies a thumb on the scale. One that hasn't got a lot of play recently, but I think is sort of bubbling up, is maybe a new Pierce v. Society of Sisters type case.
Oh, yeah.
This case from 100 years ago says there is not only a moral right, but a constitutional right for parents to direct the upbringing of their children. But we're seeing so many instances in which maybe education bureaucrats and others think, oh, no, we're the ones with the right to direct the upbringing of your children. So I wonder if under the right set of facts, Pierce can.
I totally agree. I think it's overdue for Pierce was a case where, the progressives in the 1920s, they had all sorts of great ideas about how to fix things. One of the things the progressives wanted to do was outlaw private schools and force you to send your kid to a public school. And the Supreme Court said no. In Pierce versus Society of Sisters, they said parents have the right to decide to direct the upbringing of their children. And in 2000, the court decided a case called Troxel versus Granville, where they again said, you have we talked about fundamental rights. You have a fundamental right to direct the upbringing of your child. That actually is involved in that Indian Child Welfare Act case that I talked about called Brackeen. There, the parents of the child wanted the child to be adopted by the non-Indian family. And so one of the issues we briefed in our brief in that case is we said, that's a fundamental right. Parents have the right to direct their upbringing of their children, including deciding whether those children should be adopted or not. And we hope the Supreme Court will say something to that effect. But you're right with this school choice movement going on, especially now with it having gotten a shot in the arm, so to speak, by the deplorable behavior of the teachers' unions during the pandemic. I would not be surprised if the court decides is to take some future case to reemphasize that parents should be in the driver's seat, not government bureaucrats when it comes to students' education.
100%. And then, of course, there's always, First Amendment distinctions, commercial speech, and maybe the court coming out and clarifying that, the First Amendment means what it says, and dividing the speakers, among different categories of speakers, and some get more protection than others. Maybe that begins to get or continues to get curtailed.
Yeah, that would be nice. And particularly, that's another one of those areas where you mentioned states can be more protective than the federal government. Even if the U.S. Supreme Court doesn't take up that question, I think it's really past time for our state Supreme Courts to say, distinguishing between different types of speech and saying commercial speech doesn't get protection, but non-commercial does, and all these sorts of things. That doesn't apply here. Here, our state constitution protects all kinds of speech against all kinds of censorship. That would be really refreshing if the courts were to do that. Well, I wanted to make a point of saying one of the questions in the Q&A is this being recorded so that you can listen to it? It is being recorded. So if you missed the first half hour, I don't know how you could reconcile yourself to having missed our brilliant commentary for an entire half hour. I would be pretty disappointed if I were you. So I would make sure when you do get the recording to listen to it 2 or 3 times to make sure that you get every detail.
And I think we are right at the hour, Tim. So it's always wonderful hearing from you and the insight you provide. Appreciate everybody being on and joining the call. This was a monumental term. I think that there's a lot more to come. And, all the action, while there's a lot of action at the Supreme Court, while we're involved in some of it, a lot of it is also being done right here in our backyard at the state level in our state courts. And we'll continue to fight for freedom on all those fronts.
That's right. Thank you, John, and thank you all for joining us.